shelter standards are those minimum performance standards. They're minimum standards that provide a framework within which shelters can develop a secure environment and organize your service delivery and evaluate if you are meeting those standards, if you are delivering those services appropriately. Excuse me. Goodness, my throat is a little crazy this morning, so I'm going to apologize in advance. And it is important to note that compliance with these standards is part of your contract between federal and state funders and your agency. So if you're an agency that receives federal funding, if you're an agency that receives state funding, then complying with these minimum standards is part of your contract in order to keep receiving that funding. So one of the things that's included within these shelter performance standards are the individual eligibility requirements for family violence shelter services. These are basically what standards a victim needs to meet in order to be eligible for your shelter services. And so here is what they have to say. To receive shelter services, an individual must customarily reside in a household with the perpetrator or be a victim of sexual assault or harassment like stalking where the client's customary residence has been made unsafe. Shelter clients should be individuals who've had their welfare put at risk by a perpetrator, or an individual who can state that they've experienced some form of domestic abuse at the hands of their partner or at the hands of a family member. And this includes physical abuse, but it also includes sexual, emotional, verbal, financial, and other forms of abuse. So we're not just talking about someone who has had physical injuries or altercations. We're talking about individuals who have experienced any number of types of abuse that are sort of on this spectrum of domestic violence. A lot of times, a client may not describe themselves as being in fear of or having experienced domestic violence. That might not be how they categorize themselves. That might not be how they think of themselves in terms of their relationship. They may know that, you know, there's control happening, there's hitting, there's all of these things happening. There's someone who may be screaming at them, someone who may be intimidating them, but it's hard sometimes to understand ourselves as victims of abuse and to sort of rationalize and accept that that's happening to us. So if a potential client is kind of unsure, advocates should take the time to walk them through what domestic violence is and examples of different types of violence, and you can use that by using the power and control wheel and kind of walking them through those examples of types of violence and control that are on that wheel. That's a very simple, easy to do method of walking someone through that scenario. Individuals are eligible for services if they meet these requirements and are adults 18 years of age or older, or are emancipated, legally emancipated minors, okay? And this also includes minor children and independence of adults. So if adults coming in with their children are also automatically eligible for your services. And it's important to note when we're talking about eligibility that if someone has temporarily fled abuse into homelessness or is temporarily maybe staying with a loved one or friend to flee abuse, this does not alter the client's customary residence. So remember, this previous definition says that shelter services, an individual victim must customarily reside in the household with the perpetrator. This means the place where, in the settled routine of someone's life, they regularly or normally live in a place that is shared with their abuser. So if they flee abuse from their home and they flee into homelessness, or they flee to a friend's house for a few nights, this does not alter their customary residence. Homelessness is not a residence. Being able to stay with my friend for a night or two until I find a safe space is not a residence. Customary residence changes when they receive safe long-term housing, okay? Now, am I saying that if somebody has been homeless for 3 years, and yes, their initial homelessness may have been caused by abuse, does that mean someone who's been homeless for 3 years qualifies for your services? Probably not. But if somebody has been homeless for a week or two because they fled home to avoid this abuse and they're just now finding out about your services, then yes, they probably do qualify for your services. So another thing that shelter performance standards really get into are environment, the environment of a shelter, the physical plant space. We're going to talk more about shelter environment during a later webinar. Our webinar on May 17th will be all about creating a safe and welcoming shelter environment, and we'll go through a lot of what the shelter standards say about that particular issue. But I do want to mention one thing about environment today, and it's something that I've heard a couple of times in the past few weeks from different people, from different shelters in different parts of the state. I'm hearing kind of the same report, and that is, it seems like there are a few shelters across the state who are wanting individuals to, or even requiring individuals to be gone during the day. So they're having people come into domestic violence shelter and saying, you can only be here if you have transportation or if you have a job, because we don't allow people to be in shelter during the day. Now, that is a common practice in homeless shelters where they don't have people to staff during the day, and they require homeless individuals to be out of the shelter during the day because homeless shelters are, by and large, overnight spaces. But family violence or domestic violence shelters are not purely overnight spaces. In fact, the state performance standards, the state shelter standards require shelters to be places where violence victims can seek refuge 24 hours a day, 7 days a week, 365 days a year. We cannot be requiring individuals to leave shelter or to close shelter during the day. I just want to make that note. I just want to make that clear. If you have questions about that issue, I am happy to talk it out with you. But I just want to point that out today. And again, if you want more information about shelter environment, what that should look like, how to create something that is welcoming to all individuals, we will have another one of our shelter series webinars on May 17th. Do we have any questions about anything that we've covered so far? Any questions about shelter hours? Any questions about qualification for shelter? If you do have any questions, feel free to just put them in your chat box or your question box, and I will periodically kind of check that and answer as we go along. So the next thing that I want to talk about, based on the state shelter standards, are medication policies and medication storage. the first kind of most important thing to remember about this is that every person, every adult victim who comes into your shelter should have access to a private, secure storage space that locks. So they should have access to lockable storage. Some shelters use lockers, some shelters use little mini safes in bedrooms. Whatever that looks like for your shelter, they should have access to that with their own key or their own code or whatever to store their medication and to store any personal belongings that they want locked away. And the reason that this is so important is because we really want to make sure that our staff in shelters are not holding people's medications, they're not controlling people's medications, and they're not distributing or dispensing people's medications, because all of those things are against the law and we can get into a lot of trouble if that is happening. So making sure that there are private storage available. The second thing is, again, avoid dispensing medication even if it's over-the-counter medication. Even if you keep things like Tylenol or Advil around in case people have headaches, you as a staff member cannot be the one dispensing that. So what we do is we make sure that it is in a child-safe spot, so above the fridge, on a high shelf with child-proof locks, however you want to do that. Make sure it's child-safe, just like you would with things like laundry detergent or cleaning supplies. And then you can tell clients if you need Tylenol, if you have a headache, if you need, you know, Pepto-Bismol or whatever, it's in our first aid kit on top of the fridge, okay? So avoid dispensing medication, even over-the-counter medication. Now, there are times when you're going to have to make reasonable accommodations for people's illnesses. Some people may have medications that have to be stored in their refrigerator. Some people may have certain, you know, needs for having medication on them at all times. If they have an EpiPen or if they have medication they have to take in case of an emergency, they may want to have it on their person, or, like I said, may need to be stored in a fridge. So you may need to make reasonable accommodations, but think about how you can make them safely. You know, if you need to have your medication on you at all times, let's see if we can get you like a bag, like a little bag or something that you can wear under your clothes that you can have that on so nobody else can grab it. Or let's make sure that we store it in a spot in the fridge that small hands can't reach. Or maybe we can find a little lockbox to keep in the refrigerator where those types of medication can be stored. Okay, so we do have one question. Let me see here. So the question is, we get a lot of referrals for verbal abuse. Is this addressed in the standards? So when we're talking about domestic violence, we're talking again about all of those different types of abuse and violence that are in that DV spectrum, not just, as we often think, physical violence. So yes, if somebody is experiencing verbal abuse and threats, that is someone who is a victim of domestic violence. And as we all know, oftentimes that is an escalating situation. So it may be just that they have not experienced physical violence as of yet, and that they are trying to get help or get out of a situation before it escalates. All right, so the next thing that we're going to talk about that is addressed in the state shelter standards is services for child residents. Now, another one of our webinars in the shelter series is specifically on serving parents and children in shelter and those types of dynamics. So we will be getting deeper into this topic later on in the month. But I do want to bring your attention to a few of the services that the shelter standards particularly mention that shelters need to provide for child residents. We need to provide staff or volunteers that are trained to meet the needs of children. We need to provide provisions for adequate and secure play space and recreational activities. Outdoor space where it's available, and we understand that it's not always available, should also be secure. We need to have provisions for offering advocacy to children, not just adults, because children make up a large portion of shelter residents every year. I think it's over half, I believe, of shelter residents each year are children. So it's important to have advocacy, to have safety planning available for children and adult residents. We should have written policies concerning educational plans for children. Also written policies regarding the rights and responsibilities of children and how to orient children to shelter when that is age appropriate. Okay? If it's a very small infant, obviously the parent is going to be the one who has them. But if it's an older school-age child, we need to have plans to how to orient those children to shelter, just like we orient their parents. We should have a written policy regarding childcare, how we're going to help women find childcare, how we're going to streamline the process or make the process more secure if residents are going to care for each other's children. What does childcare look like within shelter? Are there places you refer to? We need to have written policies for that. Also, written policies and procedures regarding the reporting of child abuse. And staff should be well-versed and understand what your policy and procedures are and when and how to make those reports and referrals. Other things to have. Make sure you can provide infant car seats when the shelter is responsible for transporting children and other individuals. Make sure you have a written policy concerning nonviolent discipline and how to talk about nonviolent discipline with parents and how to practice and model that with staff and with residents. So that leads us into our core services. Core services are those services that the family violence standards have identified as basic to the needs of victims, their children, and dependents. So these are the basic services that each shelter agency who receives state and federal funding should be providing, okay? And a note from the Family Violence Prevention and Services Act from FVPSA, shelter support services must never be presented to residents as being mandatory, nor should shelter residency be contingent upon residents participating in these services. So basically what we're saying is these are the services that you are required to offer, but you cannot mandate that residents take advantage of them, okay? So here are the services that are identified as core services. You have 24-hour crisis hotline. This service may be a contracted services. I know a lot of shelters across the state contract with PCAT to answer overnight and on the weekend, so that is allowed. It may be operated directly by staff or trained volunteers, or it may be an on-call service or forwarding system if available. Answering machines may not be used, except in localities where call forwarding is not available, which should not be the case but it does make a small provision. If there is an emergency or if there is a situation where answering machines must be used, they can only be used for up to 1 hour, and then staff must immediately return calls from the answering machine. So the answering machine is our last possible line of the defense, only if there is no other way available for those phones to be answered, and only if you use it for 1 hour at a time. So hopefully that's clear. I know most of you are not having that issue. I know a lot of you have volunteers and on-call staff, and like I said, a lot of people are using the PCAT hotline services as answered. Okay, so we have another quick question. This is about children's services. The question is, so other residents can take care of residents' children. What kind of policy would need to be in place for this? So the answer is yes. If your agency chooses to allow that, a lot of agencies across the state do, because the reality is our residents have work, they have appointments, they may have case management with advocates where we don't want their children to have to be in there with them listening to a story of abuse or listening to their case management session or their advocacy session. They may need to go to court, they may need to go to a grocery store, they may just need to take a shower. So yes, residents can watch other children's residents, or other residents' children, rather. Typically, for shelters that do allow this, they basically have what's called a babysitting agreement. It's a sheet of paper that basically says, I, Jane Doe, authorize Betty Sue to watch my children on this date from this time to this time, and it's signed by both residents. And typically what happens is we just have these babysitting agreements out so that if a resident needs one, they can grab one. I know there's a couple of agencies that have like little clipboards hanging on residents' doors. So if they say Jane Doe goes to the grocery store and lets Betty Sue watch her kids, they sign the babysitting agreement, they clip it to the clipboard on the door. That way, if something happens with one of the kids and the staff goes to get the mother, they can see the agreement and they can see, okay, well, Betty Sue is watching them right now, so she's the one we need to call, or here's what time mom will get back, or whatever it is. So that's how a lot of agencies do it. And if you want to talk that out with me, if you want more information, I'm happy to chat with you about that. If you want to email me or call me. We have another question that says, if you have over-the-counter medicine available to all residents, what if one resident takes an entire bottle for themselves and then ODs? Who's responsible? That resident is responsible. That resident is responsible. If somebody, that is why I said we cannot be the ones, shelter staff cannot be the ones who are distributing and handing out medication. If you store your Tylenol, for instance, in a first aid kit on top of the refrigerator and say to residents, here's where it is, if you have a headache or whatever, and they take it and take the whole bottle, then that is a choice they made that they are responsible for. On the other hand, if you are the one distributing medicine and you say, here, let me get it out of our office and hand this to you, then that is more of a gray area. So that's why we say, don't be distributing, don't be handing out medication. But yes, you should store first aid things somewhere in the shelter so that adult shelter residents can have access to it. Now, if you are really concerned about somebody overdosing on a bottle of Tylenol or whatever it is, what you can do is get those little individual packets that are like little paper packs that you tear off, and there's 2 in there. And you can have those in your first aid kit, which makes that a lot more difficult. Okay? Okay, so 24-hour hotline services, we've gone over that. I know you all are doing a great job with this. So the next core services is referral. So referral services just means making sure that advocates can create appropriate linkages and access to community resources to meet the needs of victims and their children. These linkages may include things like medical, legal referrals, mental health referrals, education, housing, and employment, social services, alcohol and drug intervention services, protective services for adults and children, mentoring and resources for children, after school and child care. All of those are different agencies you may be referring to. So referral services are really important, and this is the moment where we really want to make sure that advocates and agencies are reaching out and making connections with all of these types of community service agencies in their areas so that they can make really good, appropriate referrals. And the other thing to note about referral services that's specifically mentioned in the shelter standards is that if you have someone who calls your hotline who is eligible for shelter services, but you are full, this is a moment where you shall. The language says you are required to refer them to an appropriate program. So you need to be making sure that if somebody calls you and is eligible for services and you're full, you need to be making those referrals and not just saying, sorry, we're full. The next piece of core services is counseling for family violence victims. Now, in this case, we are not talking about therapy provided through a mental health service. Therapy is amazing. If your organization offers it, that's fabulous, but it is not a core service in this case. Counseling in this case, we're talking about services that can be provided via telephone or in person with an advocate that include things like crisis intervention and support, information sharing, safety planning, safety assessment, goal and resource development. Those types of things are included in counseling in this case as a core service. Okay, this is another really good question. Somebody asked, what kinds of medicine do you suggest having? Allergy meds, pain meds, ointments for bug bites? What I suggest, honestly, is if you want to buy them individually, kind of go and check out what's typically in a first aid kit. Things like Neosporin, things like Band-Aids, things like Tylenol or Advil, maybe Pepto-Bismol, maybe Benadryl if you've seen that be a common need for allergy medication, but that one's less necessary. If you want to purchase something for bug bites, I think that's fine, but just kind of those basic first aid things to get you through. And you can really just buy a pre-created first aid kit to store and just refill it as things run out, which is probably the easiest route to take. The next core service is advocacy. So we're talking about advocacy on 2 levels. The first level of advocacy we're talking about as a core service is individual advocacy, which includes preparation and referral of community resources, establishing linkages and contact with community resources to give better referrals, facilitating provision of services, so helping someone find, identify, and access services in the community is what we're really looking at here. Providing accompaniment and support to the victim, court accompaniment, hospital accompaniment, sometimes accompaniment to things like housing meetings or those types of things that are related to their abuse. So helping them identify, access, and use resources in the community. The other type of advocacy that we're talking about under this core service is systems advocacy. And that includes intervention with organizations like medical, legal, judicial, educational, mental health, law enforcement, housing, employment. So systems advocacy is really helping your clients to navigate systems. And it's really about making those connections within the systems that exist in your community so that you know who's the right person for them to contact, who's going to have the application for this thing, who's a good person that will give them some help with this process. How do they navigate this system? What is it step by step? You know, if they're going to get housing, you should be able to tell them step 1 for housing through HUD in our community is this, step 2 is this, step 3 is this, and here's what that process is going to look like. So understanding and being able to navigate those systems. Okay, so the next core service is transportation arrangements. So we're not saying that your agency has to provide constant transportation to all of your residents in shelter. What we are saying is that you should find out what the most appropriate transportation means are in your area and figure out how you can facilitate transportation for clients, whether that is staff or volunteers transporting people, whether that's commercial vehicles or public transportation like cabs and buses, whether that's local law enforcement. I know there are some agencies who have really good relationships with law enforcement that sometimes will help them transport people from far away, you know, from the far reaches of the county or area that they serve to the shelter, or other human service agencies. I know there are several areas in the state where there are human service agencies that operate shuttles and buses that help transport individuals who have low income or have transportation needs. So really this is about identifying what is easiest, what's best, what makes most sense for your community, and moving forward from there. The next thing is follow-up services. And what we're talking about here is specifically individuals who have been residents of the shelter. Follow-up services may include any services that you use to assist in stabilizing the victim's circumstances. So following up and offering them continued goal planning. Maybe they want to continue attending support groups. Maybe they need some continued advocacy services and resources to go with them to court still, even though they've already found housing. So what we're talking about is really making sure that just because someone finds permanent housing or someone graduates from your shelter services, that we are not cutting off their services just because they may not need shelter anymore. If they still need these kinds of supportive assistance and advocacy, that we're still providing that. The next core service is community education. This is service provided by staff or trained volunteers through things like public awareness campaigns, public speaking, training activities, media messaging. Basically, what we're doing here is informing the community of our services and educating the community or specific groups within the community about domestic violence and sexual assault. So informing and educating here. So these two core services are talked about within the state shelter standards in different areas of the document. But under FVPSA specifically, they are identified as core services. And those two things are, again, specialized services to children, which we've already talked about a little bit, and which we will talk about more as we move forward in our series of webinars. And the other thing is specialized services to those in underserved or inadequately served populations. And we're also going to talk about that a little bit more as we move forward in this webinar and in our future webinars in this series. And so the final thing is confidentiality in shelter, having a confidential shelter location. And so the interesting thing about this particularly is that there is a Tennessee state law that helps maintain the privilege of shelter locations. And that's under Tennessee Code Annotated 71-6208. And it says that no person can be compelled to provide testimony or documentary evidence in a criminal, civil, or administrative proceeding that would identify the address or location of a shelter. Okay? So any proceeding involving a shelter or a person staying in the shelter, if there is a criminal or a civil proceeding, they cannot be compelled to testify about that shelter location because we want to keep the location privileged. The other thing that this particular code says is that any process involving a shelter or a person staying at the shelter, the sheriff, constable, or other person serving legal papers shall serve any such papers by contacting the shelter and making arrangements. So basically what that means is if the sheriff or whoever needs to serve somebody papers, they can't just come to the shelter unannounced. They have to call the shelter office and talk to staff and make arrangements or have a process for that. And we're going to go a little bit more into what confidentiality looks like and what it means. So I have a couple of questions for you here. So you all should see that you have the ability to raise your hand. So when you look at your dashboard, you should see a little hand icon that you can raise. Does everybody see that? If you do see it, will you go ahead and raise your hand for me? Awesome. Great job. Thank you so much. So I'm going to go ahead and put your hands down, and I'm going to ask you a couple of questions. first question, how many of your shelters confidentiality is governed by HIPAA? So how many of your shelters abide by HIPAA confidentiality standards? If you are one of those shelters that does, please either raise your hand, or if you can't find your little hand raiser button, you can just say yes in the comments box. So again, the question is, how many of your shelters abide by HIPAA confidentiality rules? Okay, quite a few. So here is our next question. How many of you run agencies which employ licensed therapists, licensed nurses, or other medical professionals? Either raise your hand or say yes in the comments box. Okay, a few of you. Wonderful. Okay, last question of if we're choosing between HIPAA, FVPSA, and VOCA, how many of you think HIPAA has the strongest confidentiality protection? Again, if we're choosing between HIPAA, FVPSA, and VOCA, how many of you think HIPAA has the strongest confidentiality protection? Either raise your hand or say yes in the comment box. All right. So I'm going to talk a little bit about what HIPAA is, because I hear a lot of agencies that I talk to talk about confidentiality and how breaking confidentiality is a violation of HIPAA. HIPAA is the acronym for the Health Insurance Portability and Accountability Act, passed by Congress in 1996. HIPAA regulations apply to covered entities, which are health plans, healthcare clearinghouses, and healthcare providers. The primary goal is to make it easier for people to keep health insurance. The HIPAA privacy rule creates a minimum standard for protection of private protected health information, regardless of how that information is maintained, and describes permitted uses and disclosures, and when consent for disclosure is and is not required. Basically, HIPAA is meant to assure that individuals' health information is properly protected while allowing the flow of health information. HIPAA makes the assumption that information will be shared and gives medical staff the discretion about when and where it will be shared. So medical staff can choose to share health information for treatment, payment, healthcare operation, sharing with business associates, organizing healthcare arrangements, share with affiliated entities, with researchers, and for public policy work. So there's a lot of cases in which your healthcare information can be shared under HIPAA. So the basic things to remember is that with medical services, with HIPAA, doctors' expertise regarding patient information is the most important thing, and medical staff are the ones making decisions for patients most of the time. With victim services, things like VOCA, FVPSA, and VOCA, survivors are considered the experts in their own lives, and survivors are the ones deciding when to use information and make it available. At its core, HIPAA assumes that personal information needs to be shared in order to facilitate the best treatment for an individual. And in many cases, sharing can be done without the knowledge or consent from the patient. HIPAA simply establishes rules around that sharing, which makes perfect sense because in reality, HIPAA is governing health situations, and we want to make sure that experts are the ones making healthcare decisions in life and death situations. However, in victim services, if we are the ones making decisions about someone's privacy, we could endanger their lives more. Survivors are the experts in their own privacy and their own lives. So, in order to ensure the safety of adult, youth, and child victims, grantees and subgrantees shall protect the confidentiality and privacy of persons receiving services. So I am not going to break down between VOCA and VOCA and FVPSA for you. We could go into a lot of detail about the nuance of what each one of those says. But for the most part, all three of those have been kind of updated to meet the same really stringent confidentiality standards. So they all say very similar things. Basically, that's this. Shelters must protect the confidentiality and privacy of people receiving services. We may not disclose, reveal, or release any personally identifying information collected in connection with shelter services, regardless of whether the information has been encoded, encrypted, or otherwise protected. There are a few cases where information can be shared. Number one, with client consent with a release of information. A release of information must be informed, written, and reasonably time limited. So what that means is that we should never, ever be requiring individuals to sign blank releases of information. We should always be telling them exactly who we want to share information with, what types of information may be released, what resources the information may be released to, under what conditions the information can be released. And it should be, again, reasonably time limited. The basic standard is 30 days. So we have to make sure that we are giving people informed consent to signing releases of information. The next instance when information may be released is when there is a court order. The best practice nationally is to ask the court to quash or invalidate any subpoena that asks for a program's records. Responding to subpoenas can raise unique questions. We understand that it can be very stressful, that you might not have the resources to deal with or understand that. For help in responding to subpoenas, programs should contact a local attorney with knowledge regarding federal and state confidentiality laws. Programs may also contact the coalition's legal clinic or NNEBV safety net project for resources about addressing subpoenas. If the court does not quash the subpoena, if they move forward with the subpoena despite motion to quash, then shelters should limit the information released to the minimum required to fulfill their legal obligation. So only provide that specific information that is asked for in the subpoena, the minimum required to fulfill your legal obligation. You must also take steps to protect the privacy and safety of those impacted by the disclosure. That may mean if somebody is still in your shelter, finding another shelter location for them to go to. That may also mean if somebody is not in your shelter anymore, making every attempt to contact them and let them know that disclosure has happened. Child abuse reporting. So again, the law very specifically states that confidentiality does not extend to child abuse. So if child abuse or elder abuse is happening within your shelter, you still have an obligation to report that regardless, okay, regardless of confidentiality. And the last case is medical emergencies. If somebody is severely injured or unconscious to the point where 911 needs to be called, then that is a point where confidentiality can be breached. However, in these cases, excuse me, in these cases, staff shall provide emergency operators enough information to respond, for example, the location of the program and general nature of the emergency, without giving out personally identifying information about a client. For example, the program may say something like, there is a middle-aged woman having chest pains, or there is an abuser attempting to enter the shelter. If a survivor is conscious, the survivor can choose what information they want to share with medical personnel or police when they arrive. What the survivor chooses to share with the first responders is their choice. It is not the program's right or obligation to fill in the blank about a resident's medical emergency. Okay? We had a couple of questions. Are we required to share client's location if law enforcement or CPS shows up? The short answer is no. If someone shows up at the shelter's door, you are not required to say that your client is in shelter. The fact that they are a resident in your shelter is still confidentiality. It's still confidential, and you are not required to share that. If someone calls you and asks you about a client, you are not required to share that. Now, what you may want to do is talk to your organization's legal counsel and have them kind of write up a policy or procedure of what to do if that happens based on the laws around confidentiality, so that you and your staff are clear about the procedure in case that does happen. The other question is, we know that we need to report to CPS if an incident occurs that we are aware of. However, what if we are not aware and they show up regarding a case? So again, if a report has been made prior to someone entering shelter and there is an open CPS investigation, you're not required to tell them that your client is staying in shelter. But with CPS investigations, honestly, the best practice that I have found is to really talk with that client and figure out if you can set up a time for CPS to do their visitation. Because that is going to help the client's case go a lot smoothly if they facilitate them cooperating. So, at the end of the day, advocacy programs should follow the most protective confidentiality laws that apply to them. If you are an organization that does employ medical professionals, then you must follow the HIPAA privacy rule. But knowing that VOCA, FVPSA, and VOCA are more stringent, you should follow the most protective law that applies to you. So you may still want to follow VOCA regulations because they're even more protective than HIPAA is. Although HIPAA does provide a much more detailed set of requirements on electronic records that can be helpful. So quickly, a note about non-discrimination. The program must have a written non-discrimination policy with regard to sex, race, religion, sexual preference, national origin, disability, age, and marital status, So you must have a written non-discrimination policy, and the state shelter standards do go into detail about what that policy should look like. So for instance, you should have access to translation services and interpretation services like Language Line for immigrant and non-English speaking survivors. You should have a shelter location and an office location that are wheelchair accessible for survivors with mobility disabilities. You should have access to TTY or TTD services to help communicate with deaf survivors. You should be offering equitable services to LGBT folks and male survivors and dependents just as you do to female survivors. Okay? So all of these things we will go into more detail in future webinars, but all of those things are considerations to take into account as you're creating your non-discrimination policies and procedures. You also need to have a grievance procedure, and you need to define the timeline within your grievance procedure so that each step is 24 hours. So for instance, if you file a grievance with our executive director, the executive director will respond to your complaint within 24 hours. If a satisfactory resolution is not reached, you may present the problem in writing to our executive committee. The executive committee will respond within 24 hours. Okay? So you need to make sure that those timelines are written into your grievance procedure, because several agencies have received findings lately on not having those timelines defined. So there is another question. The question is, can we have different shelters for male victims, or do they have to be housed in the same location as our female victims? So a lot of shelters are still housing male victims in hotels, honestly, and that is not the best practice because it is not an equitable service at the end of the day, but it's still happening. So what I would say to that question is, if they are able to receive the same services as a female victim in this other shelter, then that's fine. So for instance, thinking about things like if your minimum stay is 30 days, then are male victims able to also stay 30 days? And so that's why I say a lot of times hoteling male victims is not an equitable services, because 9 times out of 10, we cannot pay for a male victim to stay in a hotel for 30 days or 45 days or whatever it is. But if in this other shelter location you can house them for that same length of time, then that's fine. Do they have the same access to supportive services? So for instance, if you have an advocate in person in the women's shelter 24 hours a day, do you also have an in-person advocate in the male shelter? If you have a fully stocked kitchen and toiletries in the women's shelter, do you also have those resources in the men's shelter? If you hold support groups for women in the women's shelter, do you also hold support groups in the men's shelter? And so on, just making sure that both groups are receiving the same types and the same level of services. And if that is the case, if they are able to receive those same level of services, then yes, it is fine to have separate buildings to house. All right, so a note about next steps. So as I said, this is the first of a series of shelter webinars. The next one, which will happen on the 10th, which is next Wednesday, will be about rules reduction in shelter and how we can implement rules reduction models. The On the 17th, we will be talking about trauma-informed environment, and we'll go deeper into serving victims with disabilities, serving LGBT folks. And then on the 31st, we will have a webinar on working with parents and children in shelter. I also want to draw your attention to a couple of trainings that are in person that are coming up. Our 2-day Shelter Institute, where we'll be talking deeply about all kinds of shelter issues, and we're really trying to make the Institute interactive with a lot of time to practice and learn how to actually implement different best practices. The East Tennessee Institute will be on June 20th and 21st. The West Tennessee Institute will be on June 26th and 27th. And again, for those of you who are not aware, you can always contact the coalition or contact me directly. If you need customized training for your shelter staff, I know a lot of you have very small staff, so you may not be able to send everyone away to a training. If there's a specific topic or training that you would like for your staff, we're happy to set something up and come to you. So does anyone have any questions before we wrap up? 2 people have asked, do you know where the Shelter Institute will be held? We have not secured a space as of yet for the East Tennessee Institute. We are looking at a space in Knoxville, and we are also looking at a space in Morristown. And part of it is going to depend on the number of people who register, but it will be in that kind of Knoxville, Sevierville, Morristown area. And as soon as we secure the location, we will let you know. Other questions or concerns? You can also feel free to email me or contact me directly to talk about any of these things that we've talked about today, to get more information, to get more resources. I'm going to stay on the line for another minute or two to talk about, to answer questions and talk to anybody who has a moment. I will be sending out the PowerPoint as well as an attendance certificate in the next couple of hours, so be on the lookout for that. And otherwise, if you don't have any questions, thank you so much for attending, and we'll see you next time. All right, Kyla says, can I get clarification on the child care form? Would this not make us somehow responsible for the child if something happens because it's a form we provide? No, simply providing the form does not make you responsible. We have actually talked to some people who are working in the legal field about this particular issue. We've talked to many agencies about this issue. As long as advocates are not the ones who are watching the child, and as long as both parties, the parent and the babysitter, are the ones signing the document, and that's, again, also why I said there's no reason for advocates to store the document. Just leave it out so people have access to it and let them clip it to the clipboard on their door or whatever. But as long as the mother is giving permission and the babysitter is also signing, then the babysitter and the parent are still the ones who are responsible for the child. Other questions? All right, thank you, everyone. It doesn't look like we have any more questions. So I thank you all for attending. I really appreciate it, and we will talk to you next time.